The marathon questioning of Supreme Court nominee Judge Coney Barrett is continuing on as of this taping and likely will for hours more. As expected, while the Republicans are taking the opportunity to highlight all the things that make her a perfect fit, Democrats have been grilling the nominee on where she might come down on some of the biggest issues before the high court, such as choice, guns, gay marriage, and the Affordable Care Act. But Judge Coney Barrett was non-committal.
But I can't express views on cases or pre-commit to approaching a case any particular way.
When asked whether she felt the president has the power to delay the election, the pattern continued.
I would need to hear arguments from the litigants and read briefs and consult with my law clerks and talk to my colleagues. If I give off-the-cuff answers, then I would be basically a legal pundit, and I don't think we want judges to be legal pundits.
And even on questions about whether she would recuse herself if a case arose that might decide whether or not the man who nominated her stays in office, the judge was not willing to say.
While it is always the decision of an individual justice, it always happens after consultation with the full court. So I can't offer an opinion on recusal without short-circuiting that entire process.
And so it went, with perhaps one exception or two. So did we learn anything from this hearing today? I'm joined by Katie Barlow. Katie is the social media editor at the Peabody Award-winning SCOTUS blog, the go-to source for all things Supreme Court. Katie, great to meet you. Thanks so much for being here.
Happy to join you.
Now, Democrats can't say they're against every conservative nominee. They can only say they're against the conservative nominee who, according to them, is out of the mainstream. Did her answer today to Senator Klobuchar, saying that Roe v. Wade was not a, quote, super precedent, unlike, for example, Brown v. Board of Education, which said separate but unequal and schooling is unconstitutional, did that provide an opening for the Democrats or no?
I think it did. And quite frankly, I think that was one of the most illuminating exchanges that we saw today between Senator Klobuchar and the nominee. Senator Klobuchar was probing the nominee not on how she would theoretically rule, which, as your opening points out, she'll take the Ginsburg rule and not say how she would rule on a particular case. But she indicated that she thought that Roe v. Wade was not a super precedent, which actually, unlike her previous fellow Trump nominees, Justices Kavanaugh and Gorsuch, they seem to indicate in their hearings that that was a precedent that has been decided. Kavanaugh called it a precedent on precedent. So I think that did tell us something, that she thinks that it is not a super precedent by virtue of the fact that they were discussing it and people could disagree.
You know, the so-called Ginsburg rule from her 1993 confirmation hearing, I'm not going to give you any hint, no forecast, no nothing. For the most part, despite what you just said, as a consumer, it makes these hearings almost useless to the audience, the American people. Is that overstating it? I mean, it does give a nominee the ability to, if I can use the term, hide behind a, quote, rule that allows them to answer almost nothing.
I think that's right, although I think I would push back in two respects. First, I think the Klobuchar exchange shows you definitely that she can give her feedback on Roe, but we also saw her give a little bit of hint of what she thinks about the Affordable Care Act. She kept skipping straight to severability as the main issue, which actually bypasses the constitutionality question, which will come up to the court, but she seems to be ignoring that.
You know, it's interesting, the severability thing. I mean, she did try to assure, as every nominee does, to the opposing party that they respect precedent. And on a number of critical issues, I think she attempted to do that at least. But by saying that, on one hand, she's not hostile to the ACA, when people asked her about her quarreling with the decision of Chief Justice Roberts in those two cases, by saying that there was no precedent here, which I think is factually accurate in terms of the severability issue as opposed to the other ACA issues, that has got to be causing concern for a party that's hung almost all of their nomination defeat hopes on what happens at that hearing on November 10th, no?
I think it most certainly is, although if they were paying close attention, they would pick up on the fact that she's harping on this severability issue and actually ask her why she's not mentioning at all the constitutionality question, which also has no precedent since last time it came up. that mandate has been brought down to $0 and is effectively non-existent? That's a brand new question.
You know, one of the things I don't understand, and I shake my head at almost everything Congress does, so I've got to be honest, regardless these days, but when she would not answer the question about whether or not the president has the power to delay an election, I'll listen to the arguments, I'll read the briefs. There's no other side to this issue. This isn't like debating, well, I won't even make a comparison. There is no other side to this issue. Were you surprised that she refused to answer that question?
Frankly, I was surprised. You know, I went to law school several years ago, so it's been a while since I sat down to law.
I went a lot longer than you did, so go ahead.
I would think that's an easy answer. But look, I think what she's doing is preserving any future pushback and political whirlwind that would occur should she need to face the decision to recuse from such a case. It's just one less soundbite that they could throw in that further discussion. I think that's what she was trying to avoid.
You know, the other thing that I didn't understand, there are many things I didn't understand today. I didn't understand why the Democrats didn't push back on the interpretation of their Republican colleagues and of Judge Barrett of the Ginsburg rule. For the average person, what Ginsburg rule means is I can't comment about anything that may come before the Supreme Court. But let me just read you what I know you know. I'm not sure everybody at home does. In that same hearing where Ginsburg created the, quote, Ginsburg rule, here's what she said about abortion. The decision whether or not to bear a child is central to a woman's life, to her well-being and dignity. It's a decision she must make for herself. When government controls that decision for her, she is being treated as less than a fully adult human responsible for her own choices. That is un-Ginsburg-rulian as one could possibly be. I didn't hear any of the Democrats through mid-afternoon saying, excuse me, Judge, that's not what Judge Ginsburg did, or Justice, well, she wasn't Justice Ginsburg yet, did when she was before this committee in 1993. They didn't, did they?
They didn't, and Ginsburg, even though it is called the Ginsburg rule, she both broke the rule and created that rule. But the one thing that divides the two of them is that Ginsburg, before she came to her nomination hearing, was an advocate for women's rights. And as she said during that hearing, her beliefs on abortion were a natural progression and a natural part of that job as an advocate. Amy Coney Barrett, on the other hand, has not been an advocate in the same way. She has been a professor and then moved on to be a judge. And so she has taken the position much different than Justice Ginsburg, who had advocated for certain rights before the court, that she cannot speak, especially as a judge now, on certain issues.
You know, on the recusal issue, a number of Democrats have raised the issue about whether or not she, as I mentioned, she should recuse herself on any issue relating to the president. I think in general, but also specifically because Donald Trump said, I need a ninth justice because they're going to decide the election. I want to compare that, her unwillingness to answer that question, with maybe the most moving moment of the day, at least to me. She was asked about how she responded to the killing of George Floyd. Here's just a small piece of what Judge Barrett had to say.
That was very, very personal for my family. We wept together in my room.
And she was talking about her 17-year-old daughter, Vivian, who's from Haiti, who is obviously black. And I thought that was moving. The goal is always to humanize people. Yet again, when she had an opportunity to show a human side, which I think she's done beautifully with her family, when she said, do you know how many people have survived COVID? Nope, I don't. Do you know how many people have benefits for coverage from the ACA? No, I don't. I assume she didn't want to make a mistake factually, but it seems to me the answer from somebody so smart, and she is really smart, is to say, I don't have the precise numbers, but let me just tell you, I think every day about the pain those families are suffering through. Everybody in this country should have the same access, I don't know, to health care, some such thing, as my family does, or I wish everybody good health. Were you surprised there yet again that she didn't take an opportunity to do the humanization thing that obviously is part of the mission in this hearing?
Well, I think she took different parts of the hearing to humanize her role as a mother and as a professor. In fact, it felt many times like she was a very human law school professor giving us a legal lesson on standing.
That's true.
But I will say on the recusal point, the fact that the comments that she made about George Floyd were certainly humanizing, but also interesting from a legal perspective, because there are potential cases still that could still come up. report about those police officers. And after those comments, I'm not sure that she wouldn't certainly have to consider recusing herself from a case involving George Floyd's murder.
Katie, I only have 30 seconds left. I'm assuming, unless there's a Christine Blasey Ford-like moment coming, that we have heard essentially everything the Democrats have, and we'll just hear more of it later tonight and tomorrow. Is that a fair assumption?
Yes, I think that's right. It's going to go into Thursday, but I think it's safe to say, unless there's a moment, as you described, the cake is baked at this point. She will go to the Senate floor around October 22nd, 23rd, and there will be a vote the week before the election confirming her to the United States Supreme Court.
Katie, it's great to have you here. You and your colleagues do fabulous work. Thanks so much for your time.
Thank you very much.